Hello, my name's Mark Simmons and I'm part of a worker cooperative called Co-op Culture, and we help people set up, start, grow cooperatives and community businesses mainly in the UK. And this video is a very brief overview of the different UK legal forms. This is what we're going to cover in the video. We're going to look at incorporation and what does that mean, why you might incorporate, and the different legal forms available to you if you do incorporate. So, incorporation. Imagine this group of 5 farmers here. They might already be working together, they might be sharing equipment, they might be collectively purchasing the inputs for their farming and collectively marketing the produce that they produce. Now, if I was working with this group of farmers, I would probably be advising that they consider incorporation, which is the process of formation and registration of a new legal person, a corporation. So what we effectively do is create something that the farmers can be inside. It's a new legal person and they are members of it who own and control it. So what's wrong with being unincorporated? Because it's free and it's easy. You don't have to register with anyone, you don't have to tell anyone in most cases. There is a lot less regulation. You can still get a bank account and you can still apply for and get grant funding. Now, the downside of it, and the reasons that I'd probably be advising these farmers to consider incorporation, is there's no separate legal identity. The law looks at these 5 farmers and it sees 5 farmers. It doesn't see the farmer co-op or whatever they've called it. And because there is no separate legal identity, it cannot enter into contracts in the name of the organisation. So individual farmers will have to enter into contracts, including if the organisation wants to employ people. You're really going to struggle if you want to own assets as well, because imagine that they want to collectively purchase and own land. Again, there's no separate legal identity to be that landowner. Some or all of these farmers will have to be the legal owners of the land, which is going to give you problems with things like succession. If one of the farmers dies, then effectively you've got a complicated situation to deal with. And the biggie is that they have unlimited personal liability. So if something goes wrong and somebody wants to sue this organisation or recover money from this organisation, they have no alternative but to actually sue the individual farmers, because again there's no separate legal identity. And these farmers are what's known as joint and severally liable. So if I want to sue these farmers as an organisation, I can sue one of them or I can sue all of them. And probably in the real world, I'm just going to sue the one with the most money. So that unlimited personal liability is a big one. But if there is no liability, if there's no likelihood of anything going wrong within an organisation, that's one of the reasons why you might remain unincorporated. So, assuming you do go down the road of incorporation and create this new legal person, you've now got limited liability. The farmers are protected inside here. Okay, they're limited generally to either the amount of the shares that they have in the organisation, or in many organisations to a token guaranteed amount towards the debts of the organisation, and that's very often in the UK just £1. Depending on which type of legal person you create, the type of legal form that you use, you can have more options for finance, and we'll deal with those in later videos. You can now enter into contracts in the name of the organisation. So this thing can employ people in the name of the organisation, it can own land in the name of the organisation, etc. So it can now own stuff collectively. So why doesn't everyone incorporate? Well, there is a downside to it. So it costs, and that's often a cost of the initial registration, but then there's an ongoing cost around the regulation. Some of the bodies that oversee these different legal forms will charge an annual fee, but irrespective of that, the administration costs you both in time and certainly if you have to employ accountants and things like that. And if you get things wrong, there's a potential that you're going to get fined as well. So there's a downside with this. So now we're just going to have a quick look at the different legal forms that you might use in the UK. It's a fairly complicated landscape. There are generally, and probably accounting for nearly all of incorporated bodies in the UK, there's a split between the sort of company legal form and the registered society legal form. And we're going to look at both of those in a little bit more detail. So companies, although there are some sort of weird and wonderful different types of companies, like unlimited companies, I'm just going to go for the three here that account for pretty much all of the limited companies in the UK. So starting on the right here, we've got public limited companies. These are things with shares traded on the stock exchange, big things like public utilities and things like that. Not very often used for co-ops and community businesses. Then we have the private company limited by shares. So it's the traditional for-profit model where people come together, pool their money in the form of shares with a view to making profit. And before this third one here, private company limited by guarantee, lots of people use private company limited by shares, even charitable organisations. However, you're very, very unlikely to create a charity that would be a private company limited by shares now, because we have this new legal form, the private company limited by guarantee, and this is that one where if it all goes wrong, the most you're going to lose a member of this is that guaranteed amount, normally £1. So on the other side of the family tree, as it were, and the registered societies, so these are things that emerged from friendly society legal forms in the 19th century. So these were the sort of legal forms that were being created around mutual assurance, friendly societies, and the early cooperative retail societies as well. And there are two different types of them, as we are today, and they are explicitly defined in the 2014 Cooperatives and Community Benefit Societies Act. If you register as a registered society, you have to choose between one of these two. The cooperative society is basically a democratic organisation that is owned and run by its members, and the key thing is it exists for the mutual benefit of its members. So things like the High Street Co-op is a cooperative society. On the other side, the Community Benefit Society looks very similar, but it actually has to exist for the benefit of the community. And when you register these things, and you register them with the Financial Conduct Authority, they will have a quite strict look at the application to determine whether it should be a cooperative society, whether there's a trading relationship with the members, or whether actually it's a community benefit society. And we'll look at those in more detail in later videos. So that's the main choices, although we wouldn't be using public limited company in most cooperatives and community enterprises. It's a little bit more complicated because there are some other kids on the block as well. So we have this thing called a limited liability partnership, because one of the ways you can be unincorporated is just to be a group of people who come together with a view to making profit. And there is a partnership act that governs that, and that you have to submit partnership accounts. But again, it has that downside that you have that unlimited personal liability. So this was used a lot by firms of lawyers where they existed in chambers and they were all partners, but they didn't like the fact that they were personally liable for the debts of their partners, potentially, so they lobbied for and got this new legal form of a limited liability partnership. Has been used by some small cooperatives as well, so it's not completely off the menu. It's quite an interesting legal form, particularly because it's tax transparent. And then more recently we got this thing called a charitable incorporated organisation created. Up to that point, if you wanted to be an incorporated charity, your main choice was to set up a private company limited by guarantee and then register that with the Charity Commission. The downside of that is you've then got two regulators, you're submitting two sets of accounts. So the charitable incorporation was created mainly to give you the option of just registering one thing with one regulator. So these are registered directly with the Charity Commission in most of the UK, but in Scotland there's a separate version of it called the SCIO, or the Scottish Charitable Incorporated Organisation, which is registered with OSCA, the Office of the Scottish Charity Regulator. Okay, so that's fairly complicated, but it gets even more complicated. And if we look at the company side over here, in about 2005, the then Labour government under Tony Blair decided that they needed a new legal form specifically around this thing called social enterprise that they were really excited about. And they did that by basically bolting on these features that are in a community interest company model, but basically sitting them on top of existing companies. So you can create a community interest company limited by guarantee, community interest company limited by shares, and a community interest PLC. And I think since 2005 we've maybe only had one of those. They thought there would be loads of KICs limited by shares, because the idea of the KIC, it restricts the distribution of profit, it restricts the use of assets. So the thinking was that it would be a way of encouraging investment into companies doing nice things, but these restrictions on the use of their assets and profits would incentivize people to invest. And so basically the idea there would be loads of these, quite a few of these, and not so many of these. But in practice, nearly all of the KICs that are set up are KICs limited by guarantee. So they basically don't do a huge amount more than the company limited by guarantee could do underneath, but have these additional features. And again, we'll look at those additional features and how you choose between all of these in later videos. This is just the whistle-stop tour. And then finally, to complete the family, I mentioned that before CIOs, you basically, to be an incorporated charity, you set up a private company limited by guarantee and then register with the Charity Commission. Not strictly true, because there was also the option to create a charitable version of a community benefit society. So if it meets certain criteria, a community benefit society can register as a charity. However, it doesn't register with the Charity Commission. In England, it registers with HMRC, so it's a charitable status granted by HM Revenue and Customs, and it's slightly different in the other devolved nations as well. So that's about as complicated as it gets. In other videos we'll explore the differences between those and particularly get into the factors that would enable you to choose between them, and we'll run through that process as well. Okay, see you in the next video.